Okay, then, Chris, let me give you another little heads up. Under federal law, Acts of the United States Congress, you can leave Nevada for a vacation of, say, a couple of weeks or so, and drive maybe up to the state of Washington, go to Idaho, or go to Wyoming or Kansas. And you can go before, you can petition a federal grand jury there and show them the evidence of corruption in Nevada, which violates federal criminal statutes. And that grand jury in that other state has a choice. They can either notify a federal grand jury in Nevada of the criminal allegations that you have brought and turn the case over to them, or that other state's grand jury can return indictments against the individuals whom you're accusing in Nevada, and then they can send those indictments to the district court in Nevada, and they will have to be prosecuted. Now,
if I might inquire further to that point, I actually have a change of venue request. Fortuitously, though, the proper venue to send it to would be the Federal Appeals Court in California, which creates its own set of issues due to the corruption in the communist state of California with Newsom over there. They have changed some judges up prior to Trump. Whenever he left office, he shook it up a bit and dispatched some different judges. They've gotten rid of Navarro out here, although the one that's come back I'm not sure is any better, because the corruption here, the money here from gambling in the state, I have had my home stolen by a corrupt judge because they had the audacity of placing me on the terrorist watch list under the USA Patriot Act, which is 10 United States Code 2358. It says that in the Patriot Act, in the bottom of the first section, I think it's parenthetical C, that if you're pendant in a prosecution indictment for domestic terrorism, they can deprive you of all due process and substantial justice under their so-called FISA courts or FISC courts, as the case may be, because of the presumption of terrorism. However, they aren't supposed to be using those FISC courts domestically. However, I can assure you they are.
Okay. I'm inclined to agree with you. I don't personally know of any such case, but I have heard rumblings. But permit me to help you understand something else about a federal grand jury. And the case law for this you'll find in charges to juries by Chief Justice J. 17 and I'm sorry, I think it was 1793, but it's Chief Justice Jay and Justice Story. Those two are recorded in the federal reports as having charged juries, and both of them make mention of the fact that the juries are the judges of the law. So if you've got a statute, a federal statute, and I have one myself, actually, I've got, one constitutional provision that is not being honored. And if I can get to a federal grand jury, I mean to make the issues known to those grand jurors. And you could do the same with the Patriot Act. And furthermore than that, if you can show that either the United States Congress, in the language that it used to enact a statute, or the practice to which that statute is being put. Either way, if either situation shows a subversion of the law and it being turned to an instrument of plunder by federal and or state authorities, then they have committed violations under 18 U.S.C. 241 and 242, and a federal grand jury has the power to make that decision and indict those federal officials. Plus, they have the authority as judges of the law, which is not an authority given to any Article 3 judge. Then they can tell the United States Supreme Court that this law will no longer be enforced this way in grand juries in the federal judiciary. Now, that's, if you want some idea of what kind of power they've got, that ought to be a bit of a light shining on the situation out there. And keep in mind, you don't have to change, and when it comes to federal law, you don't have to change the venue out to the communist state of California. You can go to a good republic like Nebraska or Kansas.
In fact, I have a case